Good afternoon, everybody. Thank you for joining Fair Housing. Just a couple of reminders before we go ahead and get started. If you need a certificate of participation, please email Marilyn and she will get that sent out to you. Also, please keep your microphones and your cameras off during today's presentation to avoid distraction. And lastly, our survey will be sent out after each session, and we greatly appreciate any and all feedback, questions, comments, possible topic options. We really depend on those surveys for future trainings as well as for our grant itself. So please take a couple minutes and get those surveys filled out. With that, I will turn it over to Kirsten with the Department of Labor.
Thanks, Kylie. I am Kirsten Small. I am an investigator with the Department of Labor and Human Rights. We'll kind of go through a little bit generally about the department, but overall we handle discrimination complaints for the state of North Dakota. And then we also handle any of the labor laws. So a lot of wage and hour laws or laws pertaining to employment. Today specifically, we're going to go through kind of a general overview of a lot of the fair housing laws that we handle as a department and some of the things to keep in mind, especially related to discrimination in housing, the kind of ways to prevent it, and just some of the general processes that our department handles. So if a complaint were to be filed, basically you'd have a better understanding of how that process might look. I have been an investigator with the department for about 7.5 years now. I do investigations for wage and hour complaints. I do investigations related to discrimination for employment, fair housing, public service and public accommodation, and do a lot of presentations for the department as well. As we go through, I will kind of be just going through obviously the presentation itself, and then we'll kind of save some of the questions for the end. So we'll have an opportunity at the end to go through any questions anybody has related to fair housing, related to anything that we discussed, and we'll kind of take those towards the end. If you're afraid you're going to forget your question, go ahead and put it in the comments, and then that way we can make sure that we'll get to it once we complete it. So with that, we'll just go ahead and begin. And I'll kind of give you a little bit of a general idea of what the presentation we're going to talk about today. Like I said, we're going to talk a little bit about what the department does. Prior to me working for the department, truthfully, I didn't honestly know necessarily what the Department of Labor and Human Rights handled. So we'll kind of talk a little bit about that. We'll talk about what discrimination is as an entirety. We'll talk about the fair housing laws, so the state and federal laws that pertain to discrimination in housing. We'll go over a little bit of the statistics and facts related to housing discrimination and the complaints that we handle. We'll go through some common issues that we have. Again, we're doing more of an overview, and then in a later presentation, I know we'll go into more depth related to accommodations and modifications specifically for service animals. So we'll kind of do more of an overview today, but keep an eye out in the coming weeks. The presentation for the service animals will come up then. And then lastly, we'll go through some of the investigator advice. Obviously, we can't, prevent any complaint from occurring in its entirety, but hopefully by giving you guys some ideas and guidance on how to hopefully prevent these issues from happening in the future, we truthfully, I did not what the department did, what they have three main kind of pillars or divisions that we handle with relation to our department. So obviously it's the Department of Labor and Human Rights. So the labor side of things is our wage and hour division. That's what handles all of the minimum wage and overtime laws. So that's the division that handles all of the wage and hour complaints, equal pay, any of the youth employment. So if anybody is working under the age of 16, we have specific regulations and kind of certifications that go for those employees. Additionally, we enforce any of the labor laws pertaining to even employees under 18 as far as what kind of job duties they can do, things like that. We do handle some issues related to labor unions and employment agencies, and then independent contractor verifications. The majority of what we handle with relation to the wage and hour division by far is going to be the wage collection. So basically, if an employee works in the state or the employer is within the state and an employee does not believe that they've been paid properly, they can file a claim with our department. We would do an investigation and look into the allegations and determine whether or not, based on our labor laws, if additional wages are due or not. So that's probably one of the biggest pieces of the wage and hour division. And then again, that youth employment certificates, or those 14 and 15-year-old employees that have to kind of register or certify with the state. That's another big piece of our wage and hour division. Another division we have is the Human Rights Division. They're separated out as being different kind of sections of law. One is pertaining to more of the labor laws, and then this is that human rights side of things. So although it's the same investigators that oftentimes are handling the complaints, and it's really the same department as a whole, it's just a lot of different laws under that Human Rights Division, and that's going to handle the discrimination side of things. So we handle discrimination in employment, housing, public service, and public accommodation. So public service could be an example of, let's say, like a city water department. They maybe cut off services and they believe that there was some sort of discriminatory intent behind it. You could file against that agency under that public service. Public accommodation would be an agency that would provide goods or services. So let's say, for example, Walmart or some sort of restaurant, go in there and you believe that you've been discriminated against, then you could file a public accommodation complaint. And then lastly is credit transactions. That would be any sort of discriminatory actions in an actual credit transaction. So whether that be in lending, like in a mortgage or a loan situation, perhaps a loan through purchasing a vehicle, something like that, those would be all falling under credit transactions. And when we look at the Human Rights Division, we'll go into each of these in a little bit more depth. But generally speaking, the Human Rights Division, the most claims we see are going to be in the employment realm, and then housing would probably follow up as second most filed on in that human rights side of things. And then lastly, we also handle education and awareness. So we do presentations, we do booths, we do various kind of public outreach, brochures, things like that, to try to provide education and awareness to the wage and hour laws, as well as the human rights protections throughout the state. We do, like I said, a lot of these kind of presentations. We do booths, we do kind of fairs, things like that, just to try to get awareness out on what the laws are, because a lot of times where we see issues of violations of the law, not in all situations, but in many situations, it's kind of just a lack of awareness. It's individuals aren't really sure what the specific laws are, and as a result, it tends to just have falters in violating the law. When we go into each section, there's laws under each. So under the wage and hour section or the labor laws, there's going to be specific laws under our Century Code and our admin code. Under the Human Rights Division, there's a few different specific laws that handle the issues that come up within the Human Rights Division. The first one being the Human Rights Act. So this is going to outline discrimination specifically in employment, public service and public accommodation, and credit transactions. All of the laws that relate to that Human Rights Act are all under the Century Code under Chapter 14. Any of the human rights issues or complaints, they're all going to fall under that Chapter 15 or Chapter 14 rather. And then the North Dakota Housing Discrimination Act, this is the one we're going to talk a lot about today. It just outlines the North Dakota laws related to discrimination, specifically in housing. So it handles kind of all of the nuances to the investigation, to what protections there are, and to kind of the process as a whole related to housing discrimination. And then the last two are both related to retaliation. And the first one being the North Dakota whistleblower law. This is a law that covers employees from being retaliated against for of alleged rule, law, or other kind of legal entity violation. So for example, if an employee is working and they believe that their employer is violating the law in some way, maybe they contact a local agency or law enforcement indicating of whatever the law violation they believe is occurring. And as a result, that individual's employer takes some sort of retaliatory action against them. Those would be things that would fall under that whistleblower law. So a little bit different than retaliation with regards to discrimination. Just because it's based on a law, it doesn't necessarily have to be based on a discrimination related law. And then lastly, that North Dakota Public Employee Relations Act, again, that is also a retaliation law, and that is one that is very specific to what employees are covered under that law. But kind of the general overview of it is that the employee would have to be an employee of a public agency. So they'd be a public employee, and they have to specifically have reported a violation under certain conditions. So they have to provide it in writing to an agency head or to a department that oversees that agency. And as a result, the employer took some sort of retaliatory action against them. That would be an employee that could file under that North Dakota Public Employee Relations Act. So we're just, again, going to go through a very brief overview just to give an understanding of under that wage and hour. I kind of talked about one of the biggest things that we have is individuals that tend to file for any sort of wage collection issues. So wages for work performed, hours of work issues, we handle a lot of those. Things like overtime, we handle a lot of that. We, again, handle a lot of youth employment and independent contractor verifications, and then sub-minimum wage. So there are laws that allow an employer to pay less than minimum wage if the employee is falling under certain conditions or performing certain tasks. And so we handle any sort of sub-minimum wage certifications, and then also, again, the employment agency. So if an employer or an agency is providing employment services to the state, they may qualify to have to license with our department. Of the wage and hour side of things, we handle a lot of calls and complaints in regards to the wage and hour section. We had about 5,833 public contacts in this last biennium. So that would have been the 2019 through 2021 biennium. That's any sort of contact. So it could be a phone call, an individual walking into our offices, somebody just sending an email or doing one of the public contact kind of reports on our website. That would be any public contact. So almost 6,000 public contacts. And then we had about 639 claims filed. And again, this can be anything related to unauthorized deductions. It can be related to failure to pay overtime, any of the wage laws. If it falls under that, they can file a complaint with our office. And so that was 639 claims filed, again, in that 2019 through 2021 biennium. And of those, of the claims filed, we had 689 claims closed in this last biennium. You'll see this in these numbers as well as in the human rights numbers. We do have more claims closed than claims filed. That's not always the case, but we tend to have a backlog just because the amount of time it takes to investigate a complaint. It does we can have more complaints kind of in a pending status. And so you may end up closing more complaints in a given biennium than were actually opened, but that's just because the claims that were opened during that period were during a certain time. And obviously, if we had a backlog and more cases were able to be closed, you can close more claims than actually were opened. One thing I always found surprising when I started at the department, I always just assumed that the Department of Labor was a larger agency. They handle all the complaints with relation to wage and hour as well as discrimination in the state. So I just assumed it was a larger agency. That's actually quite contrary. There is only about, we have 5 investigators with our department. We have 1 admin individual, and then we have a human rights director, the labor commissioner, and then also we have a director of operations. So we are a very small agency. We always have a Tuesday morning meeting, and we easily could fit into a pretty small room. So the agency itself is fairly small when it comes to a lot of these claims. Again, it can take a long time to investigate a case just because of the amount of information that may be needed, but cases are assigned in the order in which they're received when an investigator becomes available. So obviously, if we're handling all of the complaints, wage and hour wise and human rights wise for the entire state, it can be a lengthy process before it can be assigned to an investigator, just again, out of sheer manpower. So again, kind of an overview here, the human rights side of things we talked about. The biggest piece of it's going to be that employment discrimination, but then we also handled the public service and public accommodation, credit transaction discrimination, and then what we'll be talking about today, which is that housing discrimination. When we go into the kind of public contacts with human rights, you'll see it's a drastically smaller number than it was with the wage and hour. And that is kind of a variety of factors. Obviously, when it comes to wage and hour issues, there's a lot. I mean, even if you just look at the laws themselves, there's a lot more laws pertaining to the actual wage and hour side of things than there are the human rights side of things. But additionally, when you think about who may file with our department, a lot of individuals, whether it be a lack of knowledge or, just even a pride thing, we don't tend to have as many people file complaints of discrimination because it can kind of be, people may think that it's hard to prove or they aren't sure who to go to. Additionally, they may have concerns with, well, I'll just move on and carry on with my life as opposed to dealing with this or bringing it up and having to do a full investigation, things like that. So oftentimes we see less contacts with regards to human rights. Additionally, when it comes to wage and hour, obviously it's a very tangible item. It's very easy to see if you were shorted money out of your paycheck or if money was taken from your paycheck. A lot of individuals, obviously, it impacts them more greatly, just in the fact that obviously most of us depend on our paychecks each month. And so when we don't have the amount of money that we expected, it's noticeable and we would like to get that money back. Whereas, again, that discrimination side of things, people may think that it's harder to prove or, it's not as apparent. Maybe they'd like to think better of people or don't assume that they were victims of discrimination in some way. So we just don't see as many contacts with it. But as we said before, we had about 5,800 of the public contacts for the wage and hour and only about 1,700 for human rights side of things. So substantially less public contacts, 459 claims filed and 474 claims closed. Again, that was during that biennium, the 2019 through 2021. So we talk a lot about discrimination. Discrimination can be a very kind of vague word in the fact that it can be interpreted differently from different people. A lot of people, obviously, the definition itself of discrimination is indicating that an individual is being treated differently. But we do have a legal definition as far as what discrimination is related to our department. And that is treating someone differently in the sale or rental of housing because of a person's membership in a protected category. So we'll talk a little bit more about what protected categories are as we go along. But basically, when we look at what discrimination means, it's obviously treating someone differently in their sale or rental of whether it be an apartment or a home or a condo or any sort of living establishment, and they're being treated differently because of their place in a protected category. So for example, because of their race or because of their national origin, because of their disability. That would be what the legal definition is of discrimination. Under the law, even people who do not mean to discriminate are responsible for discrimination. So a lot of times we don't see people claims or individuals that come through our office that necessarily intentionally discriminated against an individual. Maybe they did have good intentions behind it, but you still may find that they have acted illegally just because of kind of between reasonable accommodations and just general provisions that are outlined because of these protected categories. It can cause discriminatory actions to have occurred, even if they weren't necessarily ill-intended. So when we talk about the laws themselves that are handled when we talk about fair housing laws or housing discrimination, there's two major laws that the department handles with relation to fair housing laws. One would be that Fair Housing Act of 1968. Now, this is the federal side of the law. Basically, it was initially put into place just to open doors to allow equal opportunity and housing to all individuals, regardless of their place in a protected category. Basically, it happened shortly after the Civil Rights Act, and which prevented discrimination in employment. And it was basically intended, again, just to prevent any sort of discrimination in a housing setting and try to provide equal access, because they were finding that a lot of individuals, specifically individuals that were coming back from war, were actually being treated differently, and individuals that were impacted by their time in Vietnam, things like that, they actually were finding it harder to be placed into housing because they were either being steered to certain buildings or neighborhoods, or they were being kind of denied any sort of rental because of their, most oftentimes, their race or their color. So we found that at the time, that's kind of what sparked that Fair Housing Act, and that put together the federal side of the fair housing law. North Dakota itself put together the North Dakota Housing Discrimination Act. That was in 1999, so relatively later. A lot of times with these type of laws, we end up having kind of a federal law that generally would supersede whatever the state law is, and then there's the state law as well. So it's kind of doubled up, generally speaking. But what the state law can provide is additional protections above and beyond what the federal law is. When we look at when we determine whether or not a violation of law occurred or not in housing cases or any case, for example, employment cases, we also have the federal law as well as the state law. There may be cases where you find a violation on the state level, but not on the federal level, or vice versa, just depending on the facts of the situation or depending on kind of the standing on it within the law. So again, those are the two major fair housing laws that we oversee when we talk about fair housing. So again, fair housing laws themselves, the entire reason that they were put into place was just to make it unlawful to treat somebody differently in the sale or rental of housing because of that person's protected category. Basically, it again was just trying to give an equal shot to all individuals who were seeking any sort of housing. When we talk about these protected categories, so we say it a lot, again, what we can look at under the law is discrimination based on a protected category. And so when we talk about what a protected category is, we mean specifically that there are certain categories or certain kind of areas that an individual could file on. They have to be a member of that group or associated with a member of that group. And the discrimination has to be because of that protected category in order for us to basically be able to file the complaint. So when I talked about there's sometimes the difference between the federal fair housing law and what the state law is, and the state law can provide additional protections. When we look at the protected categories under the Fair Housing Act, which again is that's the federal side of things, the protected categories are race, color, religion, sex, national origin, familial status, and disability. And so familial status, we mean any individual there's with children in the home that are 18 years or younger, basically have any sort of dependent living kind of thing is familial status, generally a family. It's pretty self-explanatory. But when we talk about the protections under the state law, you'll see that there's a few additional categories. So under those protected categories, obviously we still have all the same ones that the state or that the federal law has, which is race, color, religion, national origin, sex, familial status, and disability. But we also have the additional categories of receipt of public assistance, marital status, age, and then there's just most recently, this was actually in 2015, I believe, the 2015 session that we included the category of certain victims of domestic violence. And that specifically is based on individuals who are under a state program that were certain victims of domestic violence. So there's kind of specific categories that fall within that. But when we talk about receipt of public assistance, again, it's fairly self-explanatory, but it would be an individual who is receiving some kind of public assistance in their rental. So whether they receive a Section 8 voucher, maybe they receive North Dakota rent help, they could be a receipt of public assistance individual. Marital status, it can be really any marital status. So it could be that you were being discriminated against because you were married or because you were not married, because you're divorced. So marital status could mean a number of different things. Age, the way North Dakota views any sort of age protection is age 40 and over. So if an individual is age 40 and over and believes that they were discriminated against based on their age, they may fall under that category as well. So like I said, the state law actually provides additional protections above and beyond what the federal law is. So there may be cases occasionally that are filed and they're actually a state-only case, which means that they only fall under the state law because, for example, they may just be a receipt of public assistance and there's no other protected category. So it would only be viewed under the state law because obviously the federal law does not have any protections for the receipt of public assistance. So when we talk about who or what is covered, obviously we first and foremost evaluate whether or not the individual who is claiming to be aggrieved is a member of a protected category. Again, they don't necessarily have to only be the one that is a person of a protected category, but they have to be impacted by the discriminatory actions related to a protected category. And what I mean by that is, let's say you are not necessarily a person with a disability, but your significant other who also resides in the unit with you is a person with a disability. And whatever the discriminatory actions that are occurring based on that person's disability are impacting you and your living situation, it may be that you're qualified to file even though you yourself are not the person with a disability. So again, it can be a little more broad, but again, it has to be alleged violation of the discrimination laws in order to file. You can't just contact us, state, well, they're not being very nice to me, I don't think that's great. that won't necessarily fall under the protections we have with our laws. We look at whether or not the dwelling or the housing related transaction itself is covered under the law. So there are a couple transactions and different situations that kind of exempt an individual or a respondent from being an entity that can be filed against. For example, one that we see, I wouldn't say extremely frequently, but occasionally is called a Mrs. Murphy exemption. And what that means is that the individual, whatever the individual is filing against. So let's say that it's an apartment and the apartment has 4 or less units, and the owner of the units or the owner of the property does reside in one of those units, that may be exempted from the fair housing laws because of that Mrs. Murphy's exemption. When we talk about the Mrs. Murphy's exemption, we look at it very closely in regards to the fact that we are looking at whether or not the individual or the property owner actually does reside in the unit. So just because the individual is the, let's say, the son of the owner, but they're really the ones that are actually maintaining the property. They're doing most of the work, but on the legal name of the property, it's the mother and she does not reside there. It likely would not fall under that Mrs. Murphy's exemption because of the fact that, again, it's the property owner does not live within the units. Again, the Mrs. Murphy's, it does count how many units it is. So it is 4 or less units. I see that was a question. Then lastly, is the respondent themselves covered under the law? So obviously we look at whether or not just kind of on the outset, because some of this you won't necessarily find out until during the investigative stage, but we do try, especially on the kind of forefront, to determine some of these pieces of whether or not the individual or the respondent is going to have jurisdiction under the laws that we handle. But some of it obviously, again, might not actually be determined until after the case is filed because of just the nuances of not necessarily knowing how many other units they have, or whether or not they are, let's say, have some sort of religious exemption, or maybe are a community for individuals that are 55 and over, or something of the sort. You know, there are exemptions to law. We try to determine some of those before we evaluate if the case can be filed or not, but that's not necessarily always the case because it really just depends on the facts of the case. So again, we kind of talked about, are there exemptions from the law? Yes, there certainly can be some exemptions. So again, the certain sales or rentals, this is going to be falling under a lot with that Mrs. Murphy's exemption, that for fewer rental units and the owner lives in one of those units. Another exemption may be the religious organizations. So there can be some religious organization exemptions specifically related to the protected categories, except for race, color, or national origin. So regardless of, let's say they're saying you have to be of this certain religion to be able to reside in these units, they can potentially fall under that religious exemption based on the religion piece of it, but they cannot discriminate against the person based on their race, color, or national origin. So those are kind of, it's an exemption, but not from all of the fair housing laws, just pieces of the fair housing laws. Same with that private clubs. You may have a private club, but again, it can't be a restriction on the membership based on race, color, or national origin. It can be, though, that you could say members only of this, you know, certain group or certain, I guess, category, they can live in these units or they can live on these properties, but other individuals cannot. But again, even though it exempts them from many of the fair housing laws, it does not exempt them from the race, color, or national origin laws. And then lastly, housing for the elderly. So there can be some exemptions specifically related to familial status, because obviously that one is a protected category on the federal level, but it can also impact on the age level as well. Age discrimination specifically for the protected category in the state. There might be exemptions based on that housing for the elderly. So there are some exemptions from the fair housing laws. A lot of them aren't just blanket exemptions. They're not saying, oh, you fall under this category, you can go ahead and discriminate against anyone. It's just discrimination from specific categories that you may be exempted if you fall under these exemptions. One thing that we do see a lot with relation to discrimination in housing is publications. So the publications law itself does state that a person may not make, print, or publish or affect the making, printing, or publishing of a notice, statement, or advertisement that is about the sale or rental of a dwelling that indicates any preference, limitation, or discrimination because of the person's membership in a protected category. So this is all under the Century Code, Chapter 14. And the biggest thing here is, again, there can be issues with what we call discriminatory statements. And when I say statements, it can be actual statements, so just statements that were made, but it can also be, things that were posted or brochures, advertisements, anything like that. There's a lot of issues when it comes to concerns related to discrimination, specifically in publications. And obviously, publications have very much changed over the years. Even in the, 7 years that I've been doing this, there's been a lot of changes on how people, for example, advertise units or openings, or, how they display information to their tenants. And these publications, they can be things that are published in newspapers. They can be things that are published on social media, whether that be Facebook or Twitter or Instagram. It can be things that are posted in online ads. So for example, on BizMan online, or Craigslist, or any of the public postings, maybe on some of the news websites, or anything related to kind of that external advertising of sorts. That's a lot of things that we see with publications. Any written statements, so any memos that are left in, for example, a hallway with regards to maybe a poster board or a bulletin board on things that are happening. So publications can be written statements like that. They can be memos that were issued out in letters to all of the tenants, maybe notices that were issued out to all of the tenants, even just little things like card placards or things that they may be left in the tenants' door slots, just things that provided information in a written form. And again, they can be verbal or nonverbal statements as well. So it can be things like, obviously the verbal statements would be outward statements towards an individual, but it can be as much as even just, again, those written forms, or some sort of perhaps, I guess, labeling of a building, anything like that. They can obviously have discriminatory intent behind those. Keep in mind, statements can be well-intentioned, but may not necessarily be legal. Again, a lot of the issues we see, they're not necessarily blatant negligence. It was just a landlord maybe trying to prevent an issue that they had previously encountered, or they were trying to do the right thing, but it might not necessarily be legal. Again, the big thing is, when you're talking about those publications, is making sure that there's not any sort of advertising or statements that would indicate that you're requesting some sort of preference based on a protected category. Again, this goes for anybody who's going to be dealing with your tenants, anybody who's going to be dealing with the general public. This is why it's very important to train a lot of your staff that would handle any sort of interactions with the public, because again, it's not always a negligent statement or a statement that had ill intent behind it, but that doesn't necessarily mean that it's not a legal violation. Again, we talked about those exemptions from, and the same with the publications as we talked about previously with the fair housing laws. There can be some exemptions related to the housing for older persons, those private clubs, religious organizations, and then those shared living housing also can potentially potentially have exemptions from it, specifically related to advertisements where living areas are shared by occupants, such as roommates in an apartment or dormitory. And mostly those are related to dorms, and those are specifically only for sex only. So you could have, this is a females only dorm, or this is a males only dorm, that type of thing. But there's certain limitations on who or what kind of respondent would qualify under that shared living housing as well. So who's liable? If there is an advertisement or a statement that is made, who exactly is in trouble for making the statement? A lot of individuals could be. Potentially, it could be obviously the media that it was advertised to. It can be the individuals that made the advertisement themselves, the advertising agencies potentially, and a lot of that may fall under, I guess, mostly it's going to look at who actually put the ad out there or put the discriminatory statement out there. How was it kind of verified or checked into, things like that. And so those are some of the things that we would look at. And any other person that used the advertisement to make, print, or publish, or cause to be made, printing, or publish the advertisement with respect to the sale, rental, or financing of the dwelling. So a lot of individuals basically that are kind of any player in the situation potentially could be liable. Again, it's going to be very much based on what their hand was in the situation. So do they have some sort of verification system or something that somebody has to review the ad before it's distributed or posted? Or, was the ad posted by the person, the maybe apartment complex that actually put the ad out there? So there's a couple different factors with that. When we're looking at whether or not the statement or the advertisement is discriminatory, we look at what we call the reasonable person standard. So obviously what could seem offensive to one individual may not be offensive to another individual, and so on and so forth. And so when we determine whether or not a publication constitutes a discriminatory housing practice, we look at what we call that reasonable person standard. So we look at whether or not the statement itself indicates a preference, and that the preference is readily apparent to an ordinary reader or listener. So there can be, obviously that can be a gray area, but it's pretty self-explanatory. If an ordinary reader or listener would or could determine that that indicated a preference, then obviously that may constitute a violation of the law. When we talk about the terms to avoid, obviously making sure to label the apartment or the actual place you're trying to rent out, try to describe the unit, not the tenants you want in it. So making sure to avoid that you want, an adult, a bachelor, a couple, family, mature, anything like that, maybe indicating that it would be not ideal for an individual with any sort of disability, or that maybe it's not best for an individual who is of a very religious background. Again, talking about the unit itself or the building. So maybe it's a house, maybe it's just an apartment unit, maybe it's a condo. Talk about the unit or the property itself. Don't talk about the people you wish to have in it. Again, general rule of thumb, and we'll say it again and again because oftentimes that's where we see problems. Is it's again coming down to, are you indicating a preference based on a protected category? So regardless of, obviously ones that come to mind that are very easy are things like, whether or not it's indicating a preference about somebody's disability or about a race. Obviously that would be very apparent to some people, but it can be other protected categories. So are you indicating it would be better suited for somebody of a certain age? Or are you indicating that it would be better for an individual maybe of a certain marital status or familial status? Or are you deterring anybody who receives public assistance from applying to rent there? Those are things that all can show preference, and that can be a discriminatory statement. So we'll kind of run through the actual statistics a little bit of the cases that we do receive, and then we'll dive a little bit more into the common issues we have. So we had about 48 total claims that were closed within our department, not necessarily filed. So when we'll walk through the process a little bit, but when we receive what we call an intake, which is kind of the initial step of starting or kicking off that process of filing a complaint, the intake itself, until it's signed and returned to us, it's not technically an open complaint. So once we receive a signed complaint, then it actually opens with the department. And so of those claims that were closed in that 2019 to 2021 biennium, we had 48 claims closed. You'll see a vast majority of those, 27, were closed through what we call conciliation, or basically resolving it between the parties prior to it going to the investigation stage. We also had 13, which were what we call no reasonable cause, which means that based on the facts and evidence, based on the investigation, we did not believe a violation of the law occurred. So we have 13 of those. We did not have any in the last biennium that were what we call cause, reasonable cause, which means that based on the facts and evidence, we do believe a violation of the law occurred. One was dismissed. We have a partnership with HUD, which is the federal side of things. And so we can investigate cases for them, and they can investigate cases for us. And some of those cases, if let's say either we start the investigation or during the intake procedures, we decide that it needs to go to HUD to be investigated, we can refer them to HUD. We didn't have any of those last biennium, but again, a lot of the cases that we do investigate are actually what we call dual filed, so we can evaluate them under the state and federal law. And then we had a handful that were also withdrawn, sometimes with resolution, sometimes without. With resolution might be that based on, after they went through everything, they've decided to just kind of work it out amongst themselves, and all is well. Maybe they moved into the unit or out of the unit, but they felt that a resolution was reached. That would be a withdrawn with resolution. Then obviously withdrawn without would be no specific resolution was found, but they did just decide to withdraw the case. So of those 48 cases, you'll see we had a vast majority of them are disability. And of those 48, or of the 28 disability ones, 24 of those were accommodation cases. So when we talk about reasonable accommodations being something we see a lot of, we really mean it. The vast majority of cases that we have through our department really do tend to be disability related and reasonable accommodation related. We also have a lot of cases that have been filed on retaliation, and then kind of just a mix down the board thereafter. You'll see that this number obviously is more than the 48 that we closed. And that's because we can have multiple bases that are filed. So let's say you filed a complaint and said, I believe that I was being treated differently because of my race and my color, or I believe that I was treated differently because of my disability and because I had requested a reasonable accommodation, the respondent therefore retaliated against me. So you may have multiple bases for the same case. So obviously disability is going to be the one that we see the most of. So what exactly is the definition of disability? So in order to be an individual with a disability, first and foremost, we determine whether or not you are a person with a disability under the law, which means that you have to be one of these three things. You have to either be a person with a physical or mental impairment that substantially limits a major life activity. Major life activities, it's not always just oh, they're unable to walk. Well, obviously walking is a major life activity. It might not be as apparent as that. So for example, diabetes can be a substantially limiting, it may substantially limit a major life activity because of the fact that it substantially limits the individual's endocrine system of being able to basically produce or digest or work through insulin. So it can be that it's not necessarily always visually apparent. It can be, for example, maybe PTSD or anxiety that results in them being substantially limited in their ability to perhaps work or handle social situations. So it isn't always very visually apparent. And so just be aware of that. They may have a record or history of such impairment. So maybe they don't necessarily have the current is maybe not active. Let's say, for example, maybe it's they have previously been diagnosed with cancer and it's currently not active, but maybe substantially limiting still, or they're being discriminated against because they had that history of having that impairment. And then lastly is regarded as. So this would be not necessarily they have an active disability in it, but the respondent thinks them to have it. So this one, we see it a lot with, let's say, anxiety, that the individual, maybe they don't actually have anxiety, but the respondent says, they're just real tense all the time. They treat them differently because they thought that they had anxiety, or they thought they had PTSD. They thought they had schizophrenia. And even though they didn't actively have it, they were being treated differently because of the respondent's thoughts on it. So it can only be discrimination if the person has a disability, right? No, like I said, the discrimination can be with the person's association to. It can be, for example, let's say the individual is filing stating that there was some sort of discriminatory advertisements that were made. The person themselves may not necessarily have a disability, but the discriminatory statements themselves were indicating some sort of preference based on disability. And so the individual may be able to file on that. They may be able to file because, again, their spouse is the one that has a disability. And because for example, accommodation is not being provided, they might not be able to have the benefits of the home. So obviously, how does it affect you? One of the big things that we see is reasonable accommodations. And again, we're going to go over a very brief overview of this because we'll talk a lot more about it during the service animal portion. But big thing with reasonable accommodations is they're basically trying to prevent any sort of barriers in a home that are preventing an individual from enjoying the benefits of that home. A lot of times it would be some sort of request to maybe modify some sort of policy or practice. Maybe it's asking to distribute their rent in a different spot than usual. Maybe it's a request to have a service animal because of their disability in a no pets facility. That could be a reasonable accommodation. Sometimes failure to provide these reasonable accommodations can be considered discrimination based on the individual's disability. So again, very similar to the publications piece of it, when we talk about what's reasonable, we have to look at whether or not it causes some sort of undue hardship on the respondent by providing it. So is it going to alter their business operations? Is it too financially burdensome? We do look at these very closely. So it's not just a broad, well, I think you're probably not going to be impacted much by it. We do look at it closely on, if it is a financial burden, for example, what is the true impact of that? And was the respondent able to provide it without altering their business needs? Reasonable modifications, kind of similar to accommodations, but these are actual removal of physical barriers, as, for example, maybe adding grab bars, maybe lowering cabinets, things like that. Oftentimes, these are going to be things that the individual themselves would have to pay for. There are some kind of stipulations to that if the entity receives public or federal funding that can impact it. But generally, that same undue hardship test applies. If you're going to deny them the accommodation, you kind of have to prove the reason that you couldn't is because, it was just too burdensome to be provided. Again, big things, reasonable accommodations, those alterations are changed to a policy, a rule, a practice, or a service. Most of those, the costs, which usually there aren't too many costs because again, it's usually an alteration of the policy or practice, but those would be the cost would be paid by the landlord as opposed to those actual modifications of the removal of those physical barriers. Oftentimes those are going to be cost provided by the tenant. Working with tenants does go a long way, and we'll kind of talk about that again towards the end, but a lot of times we don't have individuals who come to our department that are saying, I've absolutely loved my landlord, they've been wonderful, but I feel like I'm going to have to file against them. You can't entirely prevent cases from being ever filed, but it can go a long way just to work with a tenant. Again, retaliation is one that we see quite frequently. This is going to honestly, it's a human reaction. So when somebody files, for example, a complaint with our office, the respondent may feel slighted. They may feel upset and offended that the accusations are not accurate, they're not true, and they may take some sort of actions against the individual because of these allegations. Those can be perceived as retaliation. It can be problematic. A lot of times people don't necessarily think it's a big deal or that it's problematic, but it is a protected category as well, as far as it is illegal to retaliate against an individual for participating in our process, opposing discrimination in any way, requesting reasonable accommodations. It is illegal to retaliate against them for doing so. So really quick on background checks. The biggest thing with background checks is there is not currently a law related to background checks on prohibiting them in any way. But one of the biggest things you want to be just cautious of is if you're using background checks and it's unfairly kind of weeding out certain categories or protected categories, it may be causing a disparate treatment or a disparate impact. Basically, the disparate treatment is treating a particular individual unfairly. So discriminating against one individual, whereas these background checks can cause that disparate impact where that, by having them, it's unfairly weeding out individuals who are proportionally higher in, like, let's say, certain categories of incarceration rates or having some sort of felony record or anything like that. And that can, again, negatively impact certain protected groups unfairly by using background checks. And so this one just talks about a little bit about the population, the prison population, specifically in North Dakota versus the United States, because where this comes up frequently is within the United States. A lot of times we see it unfairly, disproportionately affecting African-American individuals, whereas as you can see in North Dakota, it can disproportionately impact Native American populations. So the department itself, I kind of talked a little bit about what the department does, but the biggest thing for the department is we are a neutral third party. So we just conduct fair, impartial, and thorough investigation, looking at the facts and evidence of the case. All we're doing is looking at that facts and evidence and determining if based on it, a violation of law occurred or not. So we're just the middleman, basically determining if a violation of law occurred or not. When we have this process itself, any individual who believes that they've been discriminated against has a right to file with our department. They do, again, have to establish that they do have jurisdiction. So they have to establish that the complaint itself was let's say, withstanding of it had a protected category related to it, that they are alleging it in a timely fashion, that the respondent on the surface does appear to be a respondent we could file against. That is kind of the establishing jurisdiction. And then we would write a summary of what those allegations are. So the individual might maybe initially send us 15 pages of allegations, but we realize that they really only are saying that they've been harassed and evicted because of their race, for example. So we would write a summary of those allegations on one of our formal complaints and then send it to the complainant. They would review it. If they wish to move forward with filing the complaint, they'd send it back to us signed. And then that's when we would send that to the respondent to request a response. Once we receive the response, then that's when the actual investigation starts, where we determine whether or not, based on all the facts and evidence, if a violation of the law occurred or not. And then ultimately, we do receive a response to the allegations. As far as once we receive the response and investigate it, we issue what we call a determination. And so we do issue that determination indicating whether or not a violation of the law occurred or not. And we issue that out to the parties. And we do for conciliation throughout the process. So we try to resolve it through kind of informal process before it goes to the investigation stage, before we issue that determination. Again, that conciliation, it's just informal negotiations trying to resolve the issues prior to the case going through the entirety of the investigation and ultimately having a determination made. Biggest thing as far as recommendations, just get educated, knowing what to do and what not to do. That's going to be your best bet on preventing any of these issues from happening. The other big thing is if you don't know where to go or what to do with the issue, go to an attorney that handles fair housing complaints or handles fair housing laws, because they're going to be the best bet as far as providing you information and guidance. Document everything, especially in this day and age. It's so easy to document things through text messages, emails, just document things. It's going to help you a lot if you're having problematic tenants, things like that. Having documentation of what occurred as opposed to just trying to gather it all after the fact will be very helpful. Avoid sudden and rash decisions. So make sure that, again, you have individuals very well trained. If they're handling any sort of requests with the public, make sure that they know, for example, if an individual says, you know, well, I've got 10 service animals, can I move in? Reaction may be no, but the better answer would be, we have a process for that. We certainly can evaluate it. You know, if there's a medical necessity for it, everything like that, kind of go through that reasonable accommodation process, as opposed to that sudden rash decision can be helpful. Knowing the law, again, is going to be a huge thing. But if you don't know it, contact somebody who does. Contact an attorney who has experience. They certainly will be able to kind of prevent these issues from blowing up. Be consistent with your tenants, be consistent from tenant to tenant, and ultimately be nice. Again, one of the big things we see is individuals really don't do well with, they don't come to our department saying, we've just had a wonderful experience, but I just feel like we have to file. Being nice does go a long way with tenants. It truly does. And with that, certainly open up for questions. I know we did have a question about the Mrs. Murphy's law, but I did get that one. It is for but outside of that, are there any other questions? And we can certainly, if you don't think of one now and you come with one later, you can always email us and let us know, and we'll certainly try and point you in the right direction.
As of right now, there's nothing in the chat box for questions. I'll give it another minute or so. I just want to thank you again, Kirsten, for presenting today and always being available to present to our group. It's we appreciate it very much. Again, for those of you that are still on, please fill out the survey once you receive it in your email. It only takes a couple minutes, and that will help us with future trainings and topics and how to make these trainings better. And then again, if you need a certificate of participation, please email Marilyn and she will get that sent out to you. But it does not appear to be any questions. So thank you guys all again for attending today's session. And next week we have evictions as our topic. So hopefully you all can attend that. Thanks again and have a good rest of the day.
Thanks, Kylie.